Can I ask you a question about the practicalities here of applying it? You know, the burden is going to be on the person invoking the privilege. So if the person invoking the privilege comes forward and has to make a showing that it was the primary purpose, I mean, does that help us get away from the putting a percentage on it? Because then isn't the district court either buying the argument or not buying the argument? And that alleviates a little bit of this concern that we're talking about?
I think that does help, Justice Barrett. It is the proponent of the privilege's burden, and if they can't meet the burden because the district court is hopelessly confused, one reasonable approach in that case would be to deny the privilege because, of course, our basic default is the every man's evidence rule.
But you said tie goes to the runner.
It's true, and we're kind of cheating a little bit in favor of the privilege when we do that, and I think it's out of the recognition that there are just some context where it's not really the evidentiary problem, but there's a conceptual problem in separating those out. And so I don't think there are really decisions where the district court says, well, I can't tell, so tie goes to the privilege. That wouldn't be correct, but I think as a practical matter, the way district courts think about it is when we have these two purposes, they're kind of in equipoise. We think what really was driving it is the legal one.
So do you think that in terms of what an opinion would look like if we rule in your favor, it might say something like, just to be clear, it is primary purpose, it's not significant purpose, we're not going to say really anything about what it means because we're just going to let courts continue to do what they do? Because we can't really say tie goes to the runner, right, when the burden is on the person invoking the privilege. We can't get into this whole put a percentage on it for the reasons that we've already talked about. So maybe it's best to say nothing? Is that the government's position?
I don't think there's a problem in the lower court case law, so I think the court could say nothing. I think the court could also say primary purpose when there is an identifiable primary purpose that has to be the right one. In situations where it's really close, as a practical matter, courts have sometimes viewed the legal purpose as predominating, the internal investigation context being the most salient example, and we do not intend to disturb that body of case law. I think it would be fine to say that too, but whether a long opinion or a short opinion in our favor, we don't have a very strong position on that. And I guess just to make one last point, whether to intertwine a request for business and legal advice is often in the client's control. And I think that any more expansive test that allows even a little bit of legal purpose to privilege the whole communication would really create an incentive for clients. It's not always an option clients have, but would really create an incentive where possible to combine those two requests, where I think everybody agrees that in an ideal world, clients would make their business communications and then they would send an email to the lawyers about the same issue, maybe in a little more detail because of the special legal considerations that are likely to be chilled they don't want raised anywhere else. And in an ideal world, I think we have those two emails. The legal one is withheld, the business one is produced, and I think the effect of petitioner's rule would be to take us out of that world the vast majority of the time, because why not intertwine if that's going to mean you automatically get privilege?
Thank you, counsel.